All right, so today we're going to segue into discussing issues of gender and how the courts have historically treated um, gender-based discrimination over time. And this is I mean, as much so as the civil rights era, this is a very uncomfortable area of law for me to discuss and me to teach. And having been doing this now for almost 12 years, teaching this section, the way that I teach the gender section in particular has changed significantly. And you're going to sort of see that in the difference between my slides and what I say. Because I want you to see the evolution of reality versus law, and you'll see that through what I do today. Uh, there are a few speed bumps along the way, and that's largely because one reality that we have to face if we're looking at the differentiation between racial minorities and gender-based discrimination is the very nature of the situation is women in the United States are not a minority, at least a numerical minority. And because of that fact, courts, as they've attempted to, I don't want to say modernize in this era, but break down barriers of gender-based discrimination, have ultimately had to treat issues of gender discrimination differently than they treat issues of racial discrimination, where there is actually a numerical minority. And that means that in a lot of decisions that the court makes, really through the 1970s, 80s, and 90s, they aren't very fulfilling, because the court identifies this numerical minority issue as a significant problem, and it has to create pretty much on the spot a method by which to review cases of gender discrimination that is different from racially based discrimination, but also something that is more than just regular based discrimination of groups that have not been historically discriminated against. So it's a very messy area of the law, and sort of as a foreshadow, it's only going to get messier because of the precedents that have already been established. To sort of take a look at that, we have to first identify really the similarities and differences between distinctions of gender and distinctions of race legally. And so the first bullet point that like I said, that I've had for 12 years is really sort of going to be the starting point for where you can see what problems are going to come legally in the future. And I don't mean in the future of this class. I mean in the future of court decision making and in terms of how the court handles these issues. So something that is settled in the law, and this is based on precedent, is that both gender and race are immutable characteristics. What that means is, according to the law, race and gender are unchangeable. It is something that you innately have. This is still settled law, and it absolutely does not take into account any existence of individuals who are transgendered. So if we consider that legally gender is considered an immutable characteristic, and recognize that there exists transgendered individuals whom for which race is not immutable nor actually defined clearly, then legally we're in a situation where the question should naturally become and should naturally arise out of all of this: how do we treat individuals who are discriminated on the basis of being transgendered? And the answer is, we don't know, at least legally, because the history of our case law, the history of our precedent, has taken gender to be an immutable characteristic. And so going forward, when we go through cases and we look at the precedents that are established, I want you to think about it from a lens of all of the decisions that were made that did strike down gender-based discrimination and laws that discriminated on the basis of gender. Look very closely at the precedents that they set, because they are very much shrouded in this idea of gender being an unchangeable characteristic that is permanent. And think about how these precedents, which are still good law, would affect individuals whom are transgendered. So, at least legally right now, gender and race are both considered immutable characteristics. And another thing the court also recognizes is that gender and race also have a history of discrimination. So women have been historically discriminated against, as have individuals whom are not white. So these are two things that legally the courts recognize have in common. However, the differentiation that I already sort of foreshadowed is that women are not a numerical minority, whereas almost by definition, racial minorities are a numerical minority. So the court sees this and thinks, how do we have to treat these things differently? That being race and gender, when they review things that discriminate on this basis. The court goes on to ask things like, does being a woman make you a political minority or an economic minority? And if the answer is no now, was the answer yes at some point in the past, so that there is a history of discrimination based on minority status? And all of these things are, one, they're difficult to play out legally, and difficult to determine legally, but also they're in a very overt and obvious way are ideological considerations that are also going on as the court is considering this. So there's no, it's a very distasteful area of the law, because these ideological battles are playing out at the same time that gender-based discrimination is going on and still ongoing. And the court really hasn't settled on basic definitional points, which makes the interpretation of these laws and the interpretation of precedent very difficult. The court also recognizes that there are biological differences between men and women, and we'll see this most clearly in cases that involve the draft, in cases that involved serving in the armed forces. But the importance is like, from a constitutional perspective, the question becomes, what of these differences that the court recognizes plays a legitimate role in government-based classifications? And then, which differences are reflections of gender-based stereotypes? Because the argument that the court makes is that there are some classifications that classify men differently from women that have a legitimate government purpose. And then there are other classifications which are reflections of gender stereotypes. And the court struggles with how to handle this. Because there is clearly no bright line sort of rule that can be applied in every situation. And so none of this area of law is neat. It isn't easily applied. It isn't easily determined. And you'll see the problems that this causes really after the 1970s, and how the court, once it decides that gender-based discrimination is actually a thing and something they should consider and should attempt to resolve, once the court decides that that is a reality, the question of how to do it and when to do it and under what circumstances to do it, that they should strike down gender-based discrimination legally. And that's still a question that is ongoing. And it's still a question of which there is no easy or clear answer if we look at the current court. So racially based distinctions in the law are repugnant to the Constitution, and this is good legal precedent. So much so that the court applies what is known as strict scrutiny to cases, to laws that discriminate on the basis of race. And strict scrutiny is an exceedingly high standard, which the government who has put forth that discriminatory law has to prove that beyond any sort of shadow that this racially based distinction is needed. Now, when I think back and look at racially based distinctions in the law, really since the 1930s, it is difficult for me to come up with a law written that discriminates on the basis of race, that has been reviewed by the court, that has been approved by the court. There's one that stands out, and that is Japanese internment. And when the Japanese were interned during World War II, the Supreme Court says that yes, this is a racially based distinction, yes, strict scrutiny applies, and yes, it is justified. And that's really the only time that I can say that that takes place. But this suspect classification and strict scrutiny, should it apply to gender? Well, the reason why suspect classification and strict scrutiny applies to race is because race is A, an immutable characteristic, B, racial minorities have a history of discrimination in the United States, and then C is really the linchpin. And these groups are a minority. So the court has to wrestle with this fact of clearly strict scrutiny applies to race, rational basis applies to everything else, and rational basis is a very low standard that courts need only demonstrate that there is a rational reason for the distinction in the law of treating Group A differently from Group B. But gender meets two of the qualifications for suspect classification, but not the third. So should strict scrutiny apply to gender-based distinctions, or should it not? And that's a question that plays out through the court. And the answer that I'll give you, just to sort of foreshadow, is the answer is no. Strict scrutiny and suspect classification does not apply to gender. Something else applies to gender, what is called quasi-suspect status or intermediate scrutiny, which is not quite strict scrutiny and not quite rational basis. It's somewhere in the middle. And because it is somewhere in the middle, depending on who is writing the opinion in that case, intermediate scrutiny can either look a lot like rational basis or it can look a lot like strict scrutiny. Intermediate scrutiny is sort of a moving target. What we do know in the United States is that women traditionally, from the founding of our nation onward, had very few rights. Despite what the founders wrote in the Declaration of Independence, women simply weren't seen as distinct entities from which rights sprang from their own inherent being. One of the interesting distinctions of our life under British rule versus our life as a free nation is that when that transition happened, when the United States came into existence and we shed off our colonial vestige, women actually lost rights. Women actually had more rights under the crown than they did under the United States government. And that was because a thing that had fallen out of fashion in English common law, this idea of coverture, was adopted by the new United States and basically written into law traditionally, so as in they followed it, and sometimes codified very explicitly in the law. And what coverture ultimately meant is that women as distinct entities had absolutely no rights unto themselves. all rights that women held were tied to either their husband or their father. So that if a woman had rights, it was because she was either married or someone's daughter. So the rights flowed from the male entity in their environment to the woman. Now, if a woman was divorced, or never married, or her father died, that individual, that woman, didn't have rights. So Blackwell gives us a nice definition of coverture, Blackwell's legal dictionary. And what it says is this, is that marriage made husband and wife one person in the law. That is, the very being or legal existence of the woman is suspended during the marriage, or at least is incorporated and consolidated into that of the husband, under whose wing, protection, and cover she performs everything. This was the legal standard in the United States for women largely until the 1950s, 60s, and 70s. So from our founding through at least the 1970s, in some states, this was the governing doctrine. It shouldn't shock you that because of this, it wasn't until 1970s that women could have their own credit cards and banking accounts in some states. Because the rights that they had to flow from the men within their lives. And if they chose not to have a man in their life, or for circumstances did not, they were prevented from some very basic things within our society. So this doctrine, which we adopted at our founding, casts an exceedingly long shadow. And the remnants of this doctrine of coverture can still be seen in some areas of law today. So just like I said during the race and ethnicity section, that if anything, slavery is the United States' original sin, this doctrine of coverture ranks up there really high as well, because it has really sort of in a path-dependent sort of way, by making choice A, it has locked us into a path where the outcomes we are seeing today were basically channeled by that very early decision to adopt coverture and to make it law. As I said, the doctrine of coverture starts from English common law, but the funny thing is the English basically abolish its use at almost the same time the United States adopts its use. And part of this is because of the exceeding amount of religious conservatism that was among the individuals within the colonies at the time when they break away from England. There are a lot of reasons that actually go into this choice about why the English abandoned coverture and why the U.S. turned to adopt it. But what it ultimately means is that the society in which we're going to discuss changes in gender-based discrimination is a society that has legally mandated that women are subordinate and women don't have rights as distinct individuals. And to combat that discrimination is very hard. It's hard to claim that you are being legally discriminated against when the law itself does not recognize you as a person with any rights. And that's really the platform that we're going to see all of these precedents build on. And it's not a pretty one, and doesn't feel good at any point ever still.